Good morning, everyone. We're going to wait just about one more minute, let a few more people file in, and then we will get it started. All right. Hello, everyone, and welcome to Asurint's final compliance webinar of 2025, Keeping Up with Compliance, Legal Updates for Q4 of 2025. As a reminder, the purpose of these complimentary quarterly webinars is to keep employers and HR professionals informed of the latest background screening compliance updates and best practices across all industries to help organizations stay compliant and protect their workforce. Today's expert presenter is Asurint's General Counsel, Kelly Uebel. Kelly will be introducing herself in just a minute, but before we begin, I'd like to give a quick introduction to Asurint for all of our first-time attendees here today. Asurint is innovating the background screening industry. Our powerful, customizable technology, backed by subject matter experts and personalized assistance, helps you hire the right candidates every time and faster than ever before. With Asurint, professionals like yourselves can leverage faster background checks to reduce manual workloads, minimize compliance risk, promote a safer workplace, and drive insights that boost hiring and recruitment success without sacrificing comprehensive, complete records. Couple housekeeping items to cross off before I turn it over to Kelly for your compliance updates. This presentation will run for about 40 to 50 minutes, which includes additional time at the end for questions, so please feel free to submit your questions as they pop into your head via the Q&A function on your screen, or simply enter them into the chat and we'll make sure to address them towards the end. At the conclusion of today's session, you'll be receiving an email with a link to this webinar recording to rewatch later or share with a friend who is unable to attend today's live session. You will also be receiving a copy of our popular guide, 50-State Guide, Employment Background Screening Laws. This guide is a very broad survey of laws across the U.S. and is periodically updated by Kelly and her compliance team here at Asurint, and is an excellent resource for you to share with your colleagues. Kelly has a slide referencing this at the end of the presentation for all of you visual learners, like myself, attending today. And with that, thank you again, Kelly, for leading today's webinar. The floor is yours.
Thank you so much, Ethan. I appreciate it. And welcome, everyone. Thank you for joining us today. As mentioned, my name is Kelly Uebel, General Counsel here at Asurint. I've been with Asurint for about 8.5 years now, and been in the background screening industry for 14. I've previously served on the board of directors of the Professional Background Screening Association, including as chair of the association, and I'm still very actively involved in PBSA and government relations efforts, as well as leadership development efforts. So really excited to be here today, as always, to talk my favorite topic, which is background screening compliance. Just as a heads up, Minnesota is changing weather. I happen to have come down with quite the cold this week, so hopefully able to make it through this today. But if you see me go on mute for a second, that's just to save your ears. And then, as Ethan mentioned, we will be taking questions at the end, but I do have the Q&A and chat boxes up. I do try to keep an eye on them throughout so I can answer any questions as they come up associated with the slide that we're on and the topic we're discussing. So feel free to fire away, and whatever we don't get to, I'll be following up with you after the webinar as well. Before we really get started, just a quick disclaimer as always. The information offered here is educational only. This does not constitute legal advice, and consultation with qualified legal counsel is recommended. So the agenda is consistent. If you're a frequent attender with our past quarterly webinars, we're going to start with some agency and legislative actions. Then we'll move on to litigation updates and close with drug testing, legislation, and litigation. Some pretty interesting updates in all three areas, and we probably will end up maybe a little bit early, although every time I say that, we end up going the whole time. So we'll see what happens. All right, let's get started with agency and legislative actions. The EEOC, want to talk about this. Of course, we're undergoing the government shutdown currently, so the EEOC is not intaking new cases or really operational. Not going to talk about the government shutdown here today. I'm sure everyone's had enough news on that topic. And so, really just want to focus on the fact that quorum has been restored at the EEOC as of October 7th. The new commissioner was confirmed by the Senate. And so the three commissioner quorum has now been restored. And this is really important because it's required for enacting regulations, authorizing major legislation, issuing or updating any of their formal guidance documents. And so the quorum is now made up of 2 Republicans and 1 Democrat. It's widely expected that the EEOC will now be revisiting pieces of guidance that were more controversial, and I put that in quotes because it kind of depends on your viewpoint on the topic. But there are a few pieces of guidance that were issued under the Biden administration that legal experts are widely expecting to be revisited, and that includes the Pregnant Workers Fairness Act, as well as the harassment in the workplace guidance documents. So again, expecting those to be looked at, and many legal professionals are predicting an increased focus on religious rights for workers by the EEOC, as well as continued support for reverse discrimination claims. So we have started to see the EEOC's focuses and priorities really start to shift in response to several of the executive orders issued by President Trump, as well as the administration's areas of focus. I will note that the former Commissioner Samuel's legal battle is still ongoing. She filed suit following her surprise termination because she was set to remain on the commission until July 2026. And when President Trump came into power, he fired Samuels as well as another Democratic commissioner, which led to this lack of quorum. And it remains to be seen what may happen with that legal challenge and how the outcome may impact the balance of power at the EEOC. But for now, it is Republican leaning. Final note on the EEOC is that they intend to close almost all pending charges that are based on the disparate impact discrimination concept by the end of September. So most of those should have been closed. And claims that involve disparate treatment theories will remain open. So those are 2 different concepts. But the shift away from the disparate impact discrimination theories of liability follows President Trump's executive order, which we covered in last webinar session. But just as a brief reminder, this was issued in April, and it instructed federal agencies to cease leveraging that theory in litigation. So this led to the EEOC dismissing the charges in the Sheets case, as an example, when they had filed suit against Sheets back in April of 2024 for the use of criminal history in employment decisions. And so we are already seeing an impact of that executive order from April on the EEOC's caseload and focus areas. All right, now moving on to legislation, we're going to start at the federal level and work our way down. So Democrats have reintroduced credit check bans, and this has happened off and on over the last several years, has not successfully made it to fruition, of course, and probably unlikely to move forward in the current Congress makeup with Republicans controlling the Senate and the House. But it is worth a spotlight here as Senator Warren was the introducer and sponsor on the Senate side. They're both called the Equal Employment for All Act of 2025. The language mirrors each other. And the goal of this proposed legislation is to ban credit checks in employment decisions. There's really narrow exceptions, which basically includes positions that require national security clearance and when otherwise required by law. So the list of exceptions is not long. And again, unlikely to really push forward on the federal level, but it does place a spotlight back on the discussion around whether the use of a credit check in the average employment background check makes sense, or whether it should be done. There are, of course, a number of jurisdictions such as California, Vermont, and Illinois that already place limitations on the use of this information in employment decisions. And each of these laws have different exceptions, different notice and consent requirements potentially. So I just put a screenshot of our credit checks guide there in case you're interested in the full listing and more information about those laws. You can find that guide on our website. And so over the last several years, the trend really has been to move away from using credit checks, except for when, it's relevant to the position, or maybe if the position is higher profile in terms of trust or setting the company's direction, certainly financial related positions. And so we may see some more action on the state level. All right, so one of the hot topics that we're starting to hear a lot about from clients, a lot of questions coming in, is about Philadelphia. So Philadelphia has long had its Fair Criminal Records Screening Standards Ordinance. I'm just going to call it the Fair Chance Law because that's a lot shorter. And it did just update and issue some amendments to the law at the beginning of October, and these will take effect January 6th. So a few months to really take action and evaluate what you need to do to come into compliance with the amended version of the law. And as a reminder, this law does apply to employers with one or more employees in the city, and it applies to applicants and employees. So a couple of the highlights start with individualized assessments. So you've long had a requirement to perform individualized assessments in Philadelphia, but they've broadened the factors that have to be considered as part of this to include specific examples of evidence of rehabilitation. And they do have a long list of what they see as being evidence of rehabilitation. So, completion of a job training program, service to the community. They really look at work experience before and after any incarceration or the conviction. So it's a much broader view of the candidate's or the individual's history that will be required. It also impacts the adverse action process. So the way the law is currently written, it almost reads as though you only have to send one notice to the consumer, although we know under the Fair Credit Reporting Act, a two-step notice is generally required. The amendments clarify this, that there is a two-step notification under the Philadelphia law. And prior to taking adverse action, you have to provide notice to the individual. And there are several things that have to be in that letter. So you have to identify the specific convictions considered. You have to provide a copy of the background report. You have to provide a summary of the individual's rights under this specific law, as well as a statement that you will consider any evidence of error in the criminal history records and evidence of rehabilitation or mitigation. So there is specific verbiage that will be required in your letter, as well as let them know and provide instruction as to how they can exercise their right to provide that evidence or to reach out to you and talk about the potential decision. And so Assurint right now is evaluating, updating, creating a sample pre-adverse action letter that would meet these requirements. However, the Commission on Human Relations is authorized to create samples. And so we're kind of sitting tight for a second, as I recommend you might want to do if you're impacted by this law, to see if the commission publishes. Certainly the summary of rights information would be awesome if they published an actual sample or version of that for employers to use, as well as suggested pre-adverse action language. But we will be updating and issuing a sample pre-adverse action notice and rights notice as we get closer to the January 6th date, if we don't see that published by the commission. So if you are an Assurint client, keep an eye on your inbox as we get closer to the end of the year. And we'll also be sending updates if we see any information published by the commission as well. The 10 business day waiting period between the pre-adverse and final adverse action letter is still in place. Philadelphia has arguably the longest waiting period. So that is 10 business days is still in effect. And then finally, one of the other bigger changes is it does impact the type of criminal records that employers can consider. So right now, the current law prohibits consideration of felony convictions older than 7 years. So you can basically use felonies within 7 years. There was no real time bound on misdemeanors, and pending cases can be considered as well. But this now implements a 4-year restriction of misdemeanors. And it also clarifies that you can't use summary offenses, which in Pennsylvania, generally summary offenses aren't considered convictions anyway, or sealed or expunged cases or cases that are otherwise restricted. And so important to speak with your screening provider and see what they plan to do in terms of updating whatever logic they may have in place to prevent some of that information from returning on the report. So just got a question in. So for Philadelphia, should CRAs only report 7 years felony and 4 years misdemeanor to be safe? That again, the CRA is going to make a CRA for those who maybe don't know that lingo. It's really the background screening provider. It's a consumer reporting agency. So different background screening providers take different approaches. At Assurant, we believe in applying these restrictions to the report, since if you can't use misdemeanors and older than 4 years, it's not really helpful to have those return on the background report. So Assurant will be updating our system logic to accommodate these requirements under Philadelphia's amended ordinance. There are other changes that are worth reviewing the ordinance in full on, including the ability for individuals to collect liquidated damages in addition to the other remedies they have available. There is a private right of action already baked into this law, and it now prohibits retaliation against individuals who seek to exercise their rights under this law. So again, recommend reviewing the ordinance as a whole with legal counsel. Chester County went ahead and passed an anti-discrimination ordinance. This will take effect at the end, near the end of December, December 23rd. And it actually mirrors the Allentown, Pennsylvania's recent anti-discrimination ordinance very closely, almost word for word. So clearly they must have taken some inspiration from Allentown, which is common to see, especially at the more local level. And we have seen a few counties and cities now in Pennsylvania take this approach. So I would expect this to continue to pass through various cities and counties in Pennsylvania. So if you hire in Pennsylvania, good idea to keep an eye on local legislation. This really is pretty straightforward, though, unlike some of the other fair chance and anti-discrimination laws that we've seen. It essentially prevents you from inquiring into criminal history on that initial employment application, and then holding any inquiries or any background checks until after the first interview. You can let them know if the position would require denial or requires like a free background from like a child abuse perspective, clearance check perspective. But it doesn't impact your ability to use criminal history information necessarily. It just requires that when you're considering conviction records, that you need to make sure that they relate to the applicant's suitability for employment. Now, they don't give you any sort of criteria or factors that you have to consider. So if you already have a built-in individualized assessment process, that arguably should work here. But if you don't have any sort of individualized assessment process, it's important to think about what factors you want to think about when it comes to if the position really should impact that individual's the conviction should impact that individual's ability to perform that role. So things like the nature of the offense, time passed since the conviction, any evidence that they've performed a similar role recently or following the conviction. Those are some common things that we see people consider. The ordinance also references Pennsylvania state law that requires employers to provide written notification if an employment denial is based in whole or in part on the individual's history, which of course you also have that requirement to follow the adverse action process under the Fair Credit Reporting Act. And so if you fail to provide that notice on the state level, that's also considered a violation of the ordinance. And it does establish protected classes. This ordinance prohibits inquiries into salary histories. There's some language around disability accommodations. So recommend reviewing the ordinance in full. And it did create a human relations commission at the Chester County level who will be responsible for enforcing this law. So definitely worth a read if you're impacted or hire individuals in Chester County. The last update is in Texas. So I don't know if many recall, because 2023 feels almost like a lifetime ago already, but Texas passed what was widely referred to as the Death Star Law. It's the Regulatory Consistency Act. And so what this law did was it preempted certain city and county regulations in various categories like the Business and Commerce Code, the Labor Code, and others. And so it basically said, hey, cities, you can't pass legislation that would impact these codes and conflict with state law. And so several cities, Houston, San Antonio, and El Paso, filed a lawsuit. They challenged the law. The district court found in favor of those cities. And then the appeals court ruling just came out recently, this past July, and sided with the state. And so the court found that the cities failed to show any sort of injury in fact. They failed to show that any of the alleged injuries were fairly traceable to the state. The cities didn't allege that the state even threatened to enforce the act. And so right now, the state has won, and this Death Star law is in effect. The state viewed it as being in effect this whole time. And so why this is important and why we're talking about it is that there are cities like Austin and DeSoto that have fair chance laws, as an example. There's also city regulations in a variety of cities addressing paid sick leave, predictive scheduling. There's a whole host of city legislation ordinances that are likely impacted here. So definitely encourage you to consult with legal counsel as to whether you need to still consider complying with any city laws that are remain in effect, because a lot of cities haven't taken action to rescind those ordinances that are now in theory in violation of this state law. So really recommend working with counsel as to whether you need to comply with Austin's fair chance law or not if you have employees in that city. Again, DeSoto also has that legislation. So that's worth a discussion with counsel. Litigation. We're clicking right through today. So litigation is going to be all about adverse action today because there's been a number of cases filed against employers for adverse action, alleged adverse action failures, and there's been a couple settlements I'm going to highlight as well. So this case was just recently filed against a global retailer. I do include the case citations in the footer there that you can see. But really what happened here is this potential class action alleges that individuals were denied without the employer properly following the adverse action process. So the plaintiff, the named plaintiff, alleges that she applied for a position, she disclosed her criminal history to the store manager, she was provided with an offer and completed the onboarding paperwork. And then she shows up to training and thinks everything is going just fine. She was then removed from the training and was told by the store manager that, and I put the quote in there from the complaint, that due to the results of the background check, she couldn't work. And so she's claiming, hey, I never got a copy of the report. The only way I got a report was by proactively looking on the company portal and I found it. I didn't get a summary of my rights under the Fair Credit Reporting Act. And so you didn't follow adverse action at all because allegedly, I mean, what the claim is that the store manager took adverse action by telling her that she couldn't work due to the background check, right? But apparently, as alleged, the employer did not send out a pre-adverse action letter, did not provide a copy of the report, did not provide that summary of your rights notice. And so that resulted in this lawsuit being filed. There's some other interesting arguments in this case. If you're kind of a background screening compliance nerd like me, might be worth a read because there's definitely some interesting theories. Some of them are that she claims she would have never authorized the background report had she known the employer would not comply with the Fair Credit Reporting Act. So she's trying to claim that her authorization to the consumer report is not valid because again, the employer didn't comply with the law and she would have never said, yes, I consent to that background check had she known the employer wasn't going to comply with the law. So very interesting argument there. She also alleges that the employer did not have a permissible purpose to run the background report. because it already had the information it needed to make a decision based on her self-disclosure. That is something I've not really seen personally in these types of cases. It's an interesting argument. I don't know how much validity it necessarily has. But the plaintiff's attorneys are getting a bit more creative these days. So worth reading the complaint and thinking about those other items as well. Moving on to the settlements, the first case listed here is this section, as I'm sure you can put those together with the mention of cruise lines. But it was an undisclosed settlement amount, but they did settle adverse action allegations, and all three of these are really similar in terms of the fact patterns. It claims that they never sent a pre-adverse action letter, didn't provide a copy of the report, didn't provide a summary of your rights. Instead, the employer allegedly just emailed the plaintiff that after reviewing the results, they've decided to pursue another candidate, and that was that. And so the individual really didn't have any chance to look at the report, to talk with the employer about the decision, and there you go, lawsuit settlement. The second case was a $5 million settlement, so that is certainly a significant chunk of change here. And the class included all individuals from June 22nd, 2020 to September 11th, 2024. So if you sit and think about how many people have you run a background check on during that period, and how many people did you not move forward with during that background check? I mean, that can be a pretty significant number, right? Depending on your hiring volumes. And even if it's a smaller number, the damages can really add up quickly in Fair Credit Reporting Act claims because you have statutory damages plus potentially punitive damages and attorney's fees, depending on if it's considered a willful violation of the law. So you can see that these cases can get expensive very quickly. And I do want to call out that none of the employers in these cases have admitted any liability or wrongdoing. I think that's always important to acknowledge. I don't spotlight these cases to shine a negative light on any particular company either. It's really shared just as an example of the claims that are being made against employers related to FCRA compliance. And so really, I think if there's kind of one piece that you focus on of your process right now, it's probably adverse action. We've seen a lot of disclosure form related litigation in the past and expect to see more in the future. But it does seem like the plaintiffs bar is really focused on adverse action right now. And so, having a legal review of your letters, your process, providing training to any candidate facing staff, that can go a long way in helping to protect your business. And so really, really, really recommend taking that step. Okay, and now we're going to move on to drug testing. So the DOT has published a proposed rule. The comment period's open through tomorrow, October 17th. And this is proposing to add fentanyl to the drug testing panel, the DOT's drug testing panel. And if the proposed rule is enacted, fentanyl would be updated in the urine and oral fluid testing panel, and norfentanyl would be added to the urine testing panel. There's corresponding test cutoff concentrations included. It would also amend the MRO verification process to include these drugs. And there's some other items that it seeks to change as well. It does also seek to add nomenclature for marijuana to amend the drug testing panel footnotes, just changing the reference from THCA to more specifically identify Delta-9 THC. It doesn't impact the marijuana testing process. And as we know, marijuana is still a Schedule 1. And I have an update on rescheduling efforts I'll share in a second. So no changes to the actual testing or consideration there, but just some verbiage changes that are proposed. As for the federal rescheduling efforts, they are still up in the air. President Trump has indicated, and he's indicated a few times, that he may announce plans regarding the possibility of rescheduling in the coming weeks. It's kind of tough to say what's going to happen current times. So Could happen tomorrow, could happen in 6 months, but it is something that is still a discussion point on the federal level under the current administration. So good to keep an eye on those efforts as the discussions happen. But I wouldn't necessarily expect rescheduling to occur anytime soon still. Speaking of fentanyl, wanted to include this Quest Diagnostics 2025 study that I found was really interesting on from a trends perspective in terms of where people are kind of testing, what they're testing positive for and when. And in particular, in looking at random testing versus pre-employment testing, the study found that there seems to be a change in personal drug use. So fentanyl positivity rates were much lower in pre-employment tests at about 0.14%, which is still a small percentage of tests to return positive, but that jumped to 1.13% in random tests. So it's kind of clear that there are some individuals out there that know they might be drug tested for a role, kind of hold up on their drug use, go through the test, and then resume use. So it does, if you do drug testing, it does kind of highlight the importance of, your workplace policies, your testing procedures, et cetera. And so certainly, I thought that was pretty interesting. Other drugs, including marijuana, did see less variation between pre-employment and random testing. It really picked up on fentanyl being kind of the biggest drug that changed behaviors. It also noted that of those positive fentanyl tests, 60% were also found to be positive for other drugs, most commonly marijuana, which may or may not be a surprise to some. And marijuana still remains the most detected substance in drug tests. Positivity rates are holding steady at like 4.5% of the general workforce year over year. Although marijuana positivity did decline slightly to 0.87% in federally mandated safety sensitive roles, which is interesting and a good trend to have. So certainly I put the link to the newsroom article. There's a whole report you can download, but thought it was really interesting data to review. Moving on to Massachusetts, they have been active on the marijuana front. In September, the Attorney General did certify over 44 ballot initiatives, 2 of which are aimed at rolling back recreational marijuana legalization. There seems to be a body of people in Massachusetts that don't love recreational marijuana because this is not their first attempt, I don't believe, at doing this. But initiative petitions 2509 and 2510, they're largely similar. They would allow for the possession of 1 ounce or less, but they would make possession of under 2 ounces a civil infraction, subject to fines, completion of drug awareness programs, and the state's Cannabis Control Commission would have its authority reduced to medical marijuana. So it doesn't seek to change anything with medical marijuana. It's really focused on recreational use. There's a long road for these initiatives to even make it in front of voters. So they have to turn in about 75,000 signatures from registered voters by December 3rd. If they clear that threshold, and then goes to the state legislature in January for consideration and to see if they want to adopt any potential legislation. If that doesn't happen by the summer, then they have to collect an additional 12.5 thousand signatures in order for it to go on the November 2026 ballot. So there's a lot of steps that have to happen for these, but worth keeping an eye on because it could potentially be impactful. But I think if it makes it to the state, I don't know if they'd pass legislation to roll back legalization of recreational marijuana because they are actively advancing a bill in the House, H159, that would amend the state law to be adding employment-related protections from discrimination for marijuana users. So those 2 things don't seem to be quite in lockstep in Massachusetts. But really, this bill, which has continued to move forward, so it is worth tracking if you are in Massachusetts, Really, again, it adds employment-related protections for any users, including protection from discrimination based on the presence of THC in any sort of sample, blood, urine, or other body sample. There's limited carve-outs, including for safety-sensitive roles. But this one is definitely worth watching and keeping an eye on. We have seen some states provide protections for marijuana users, and corresponding litigation then soon follows, where employers may or may not meet those requirements. So again, keep an eye on Massachusetts. All right, our last topic of the day. And again, encourage you to throw any questions in the chat you may have. As we get to the end of the year, we tend to see a lot of winding down of state activity. So that's why this one's a little shorter than usual. Usually the first and second updates of the year are probably the most jam-packed because that's when states are really active. But I wanted to highlight a recent case. This is from the Eighth Circuit Court of Appeals. And this was a win for the employer who faced a lawsuit after terminating an employee for a THC positive drug test. And so tested positive for THC, said, hey, it's CBD oil I'm using for my back pain. He filed suit saying that the handbook didn't allow for the termination and that he just shouldn't have been terminated because it was CBD oil. The Court of Appeals pointed to Arkansas's employment at will doctrine and said that allows employers to terminate employees at any time, with or without any cause. And so, thanks for your arguments, but the employer can terminate you for any reason. And they didn't find anything in the handbook that would be contrary to that finding. So I've shared this case because I think it's important to call out a few items. One, the language in your handbook is very important when it comes to defining at-will employment. If you're in a state, an at-will state, and making sure it doesn't read as though it's entering into any sort of contract, employment contract. So, really recommend having your handbook language reviewed with counsel. Also, I didn't put the note proceed with caution here because when it comes to marijuana in the intersection of state laws, different states treat this very differently. So there are some states that have what we call lawful use laws, which prevents employers from taking certain actions if someone is operating with the confines of that law. So they're using something that's lawful, considered to be lawful under state law, such as marijuana, as an example, if that state has legalized recreational marijuana use. On the flip side, some of those states with lawful use statutes don't specifically include marijuana in that statute, even if it's legalized on the state level recreationally. So it's a very complicated analysis depending on the state. So definitely recommend doing a state by state analysis if you're testing for marijuana and still take actions against individuals for marijuana related tests. Because again, it is going to differ by state, and this has been challenged in different jurisdictions as well. Nevada, we've seen cases in Pennsylvania, Massachusetts, it's kind of New Jersey, it's kind of all over the country, Minnesota. So really important to do that analysis if you are still testing for marijuana, and if you do terminate individuals or withdraw job offers based on those positive marijuana tests. With that, I think that's like record timing for a compliance webinar, which may be good given my current state of affairs. But happy to, if anyone wants to enter in any additional questions into the chat, happy to take those. Otherwise, we can definitely wrap early today. And as I give you a chance to type those in, we will be sending, as Ethan mentioned, the 50 state guide for employment and hiring. I did just finish updates to that this morning to account for Philadelphia and Chester. We also have updated our Ban the Box guide, and that will be the updated version will get posted to our website shortly to reflect those changes as well. We have several other guides on our website, including a 50-state guide for drug testing that includes an analysis of recreational and medical marijuana laws, as well as general drug testing laws for each state. So definitely recommend checking that out, along with a clean slate white paper. That topic hasn't gotten as much attention recently. It kind of cooled down a little bit in terms of being a trend. Um, but tons of resources out there for you. I did just get a question on, are you aware of any cases in Michigan regarding THC positive tests in employment? Not off the top of my head, but I will look into that and follow up with you, April, on if I can find any. And I'll send you a couple examples of other states that have had that issue too. Great. Well, with that, I think we can go ahead and close early. Again, I think this first time it's ever happened, probably the last. Really appreciate everyone's time and attention today. And if anything else comes up, always feel free to reach out to Assurant. We're happy to answer your questions. And I hope you have a great rest of your day. Thank you.